Again, good morning from a very rainy and wet Los Angeles. I have to mention it twice because it's so unusual for us to have this kind of weather. We're going to go ahead and get started, and I want to begin, first of all, with a very big thanks to our friends at SCG Legal who are co-sponsoring, co-presenting with us today. We appreciate their support. We do also want to mention that you will be getting copies of the slides, so don't be concerned about trying to write everything down. There is also a Q&A feature on the platform, so feel free to use that. Use that, please. Also, if you're having any trouble hearing us or there's any problems with the video or the audio, you may not all be seeing. Well, yeah, you actually are all seeing the video. Sorry. There's a lot of information to cover. We're not going to get into a lot of depth on some of these things because we're going to try to leave some time for Q&A. But let me just go ahead and start. As most of you know, the CCPA takes effect on January 1, 2020. The related regulations were proposed last month. Getting through those is slogging through quite a bit. They are not, however, going to take effect until July 1, 2020. But a lot of companies are trying to, of course, implement everything and do it as quickly as they can. As everybody pretty well knows now, the CCPA is requiring companies to institute new internal data privacy regimes. And so we're going to talk briefly about what those requirements look like and what some of the options might be. For those of you that dealt with the GDPR, the questions on this particular slide are going to look very familiar. If you're dealing at all with cybersecurity issues, this list of questions looks very familiar. And frankly, it's pretty much what you're going to be dealing with as you're looking at any of these cybersecurity issues and data privacy issues. The one thing that probably is a little bit odd on this slide is the last point about changing the default password. What we're finding is that on a lot of the, the hacking issues, the default passwords just never got changed. That's why we've included it there. What companies are going to need to do is to develop processes and procedures that will address the key points about notice, access, right to be forgotten, opt-out, and critically, that companies are not permitted to discriminate against those who are exercising their rights under the CCPA, absent good cause, and we're not really sure what a good reason is yet. That's something that obviously is going to need to be developed. Key questions: do you encrypt, aggregate, de-identify, or redact? When we get to talking about enforcement, the encryption and redaction keys will be more obvious. One of the critical points of the CCPA is that if you're aggregating and or de-identifying, that is not considered to be private data. The basic premise of the CCPA is that California consumers, as you can see here, now have the right to know what's being collected from them, why it's being collected, how it's going to be used, and the sources from which it was collected. So that if you're getting things from third parties, the consumer has the right to know. However, public records are not considered private records. And while it probably is wise in the current environment to disclose that you're including public records, they're not considered records that are private as defined in the CCPA. And the key, of course, to all of this is that you're not really, as the company, permitted to use the data in any way that the consumer has not pre-approved. One of the keys is that the consumer must be informed, as the statute goes, to, at, or before the point of collection. So the usual practice of many companies to have terms of use or terms of service or customer uses documents or whatever, and then also privacy policies, which you have to click through to accept, and then the company's keeping track of those click-throughs, keeping track every time the terms and conditions of any of those are amended, are also helpful to making sure that the agreement itself is enforceable in court if it comes to that. The covered parties are as you can see here, of course, the key is the 25 million, which is what's catching a lot of companies. For those of you that didn't follow the CCPA's enactment, there was an initiative on the California ballot that would have gone further than the CCPA actually does. The CCPA became a compromise, and proving yet again the old adage about not watching sausages or law being made. There are a lot of companies that are going to be subject to the CCPA that actually are not buying and selling data, but simply have it as the ordinary course of their business. The second point I've underlined here, consumers, households, or devices, because that's something that companies may get caught up in. We were talking here internally, and as a result of that, I sort of started counting through all the devices my husband and I have, and it's just the two of us in the house. And I stopped at 9. I'm not sure I got all of them. So it's not just going to be a matter of tracking the number of consumers, but it's also going to be a question of tracking the devices that they have. And then, of course, the category where everybody anticipated the privacy law would kick in, which is if companies are using the purchase and sale of data as a primary force or form of their income or their revenue. Because we are talking about companies, therefore commercial entities, nonprofits and government entities are not subject to the CCPA, which is not to say that some of them have not enacted some form of their own policies. Certainly at the federal government level, that's particularly true. All right, there are exemptions. None of these should be terribly surprising. They are all either federal or state laws that are already in place that deal with specific types of privacy rights. The one that most of us think of and is obviously quite close to the top of the list is HIPAA. I think the one that was most interesting as this went through was the last one, which is that any of these privacy laws are not to infringe on the non-commercial activities of newspapers and periodicals. One of the interesting sort of compromises, if you will, and to be clear, the CCPA was in the law last year quite early, and at the end of the legislative session, we saw it was either 5 or 6 bills get enacted quite late in the process. And going through those led to, if you're using the data internally, that is because it's for a job applicant, or it's an employee or owner, and you can see the other categories here, or it's an emergency contact or data needed to administer benefits, compliance with the CCPA has been put off for those limited purposes until January 1, 2021. Here's some of the required disclosures, and this is where we're starting to get into conversations with clients who are going, oh my God. The privacy policy really needs to tell the consumer how the data is being used, if they want to be deleted, if they want to opt out. And then, of course, as I said, not only how the data is being used, but how it's being shared. And the process can be done through a notice provided through a link on the relevant section of the online privacy policy, but it does have to be, as it's recommended, in plain and simple English. I don't want to spend a lot of time on this particular slide or a couple that follow. These are really inserted, and you'll see again, as I said, when we share them with you, these are inserted to really give you an idea of just how broad the definition of personal information is. And because it's so broad, and it does, as you can see at the bottom of this particular slide, does include biometric information, it's really important to make sure that you are making clear what you're collecting, what you're using, and how you're using. And I'm going to come back to the biometric definition in a moment on another slide. Also already in the law is a California Civil Code section that's cited here, and you can see the additional provisions that it includes. So it's pretty clear that anything that could be used to identify an individual is going to be considered personal information for these purposes. And then again, what's not considered personal information is that which is publicly available, which is not used without the consumer's knowledge in terms of biometric information. And the use of public information has to be done, as it says here, with the purpose for which the data is maintained and made available in the government records, or for which it is publicly maintained. So if you're using it, for example, in one context, or it's been collected publicly in one context and you intend to use it in another, we're going to have to look carefully at what that other use is. Also exempt from the CCPA is the single one-time transaction where the information isn't going to be used further and it's not maintained as personal identification, meaning it's been de-identified, it's been anonymized, it's been pseudonymized. in some other manner is not, as indicated, able to be traced to the particular individual. Now, I pulled up the data breach law because this is the one that has a definition of biometric data. For a lot of companies, this is going to be relevant, particularly if you're in the security arena in one form or another. But we don't, in the context of the CCPA itself, have a biometric data definition. I'm going to just jump through here. So consumers, this is the definition in the CCPA. So it's a natural person who is a California resident. Notice it does not distinguish between citizens and non-citizens or green card holders or anything like that. For those of you that have looked at the question of residency for tax purposes, this is an altogether different definition. You don't have to have a company here. You don't have to have a presence in California. This is just really all about you are maintaining data about California residents. Households are defined person or group of people occupying a single dwelling, so obviously that's not just family. That could be a group of friends that are, as the friends showed, they kind of lived in each other's houses. Here's the other device definition. So anything capable of connecting to the internet. So obviously if somebody's playing games on their TV, that would count. If they're playing games on a console, that would count. So really going to be a challenge to collect all of this information. Business purpose is defined. This is critical because there's actually a narrowing of the definition. I wouldn't call it an outright exclusion, although some might. But the idea is that if you're collecting the information for operational purposes, that is permitted. Here are some examples of business purposes. And if this is what you are doing, then the rules are a little bit more relaxed. Some would say they're outright waived. I think there's room to debate that. And certainly if you're collecting the information for these purposes, you're still going to want to identify it to the consumer so that there's no complaint later that they didn't know what was going on. But if you're auditing current interactions, if you're detecting security instances or otherwise protecting your system, if you're debugging, transient use, performing services on behalf of the business provider, verifying customer information, and so on, along with internal research activities to verify or maintain the quality or safety of a service, these are all legitimate purposes, if you will, to use that language out of the GDPR, and those are permitted. Again, although they should be flagged for purposes of what you are doing with the data. One of the key points out of the CCPA is that the privacy policy is to deal with practices both on and offline. So if you're using some of the data in the more traditional hard copy manner, for example, that does need to be addressed in the privacy policy. And of course, there is a requirement, not surprisingly, that the policy be posted on a conspicuous link. So most everybody's using either privacy or privacy policy. It does have to be on either the home or the landing page, depending on whether we're talking about a website or an app. You've got some definitions that follow here that I really included just to make clear that they're incredibly broad. And whether or not you're selling, and here's some examples of things that are not a sale. I think there's another definition later on about sharing, but the point is that whatever you're doing with the data, it more likely qualifies as either a sale or a sharing of the data, and you do need to keep track of that and you do need to disclose it. Here's a couple of things that are not a sale. I think the one that's the most interesting for everybody is you're sharing the data with the service provider to perform the business purpose. You can make an argument that that means if you've got data on your platform that you're giving to the payment processor, that you may not technically need to disclose it, although again, better to disclose and not deal with the argument about, well, gee, you didn't tell me. Here's the basic issue, or one of the basic issues that a lot of companies are going to have to decide about. California consumers now will have the right to demand access to the information that a company is maintaining about them. They're permitted to do that twice in a 12-month period. Companies can decide, first of all, if they're willing to entertain more frequent requests, and if so, they're permitted to do so. And there is the option to go ahead and charge for that. I'm sorry. Also, there's two steps to this. If you get a request to have it from a consumer asking for their data, you're required to acknowledge that request within 10 days, explain what the company is going to do, and respond to them within 45 days. Now, there is a provision that says for good cause, you can make it 90 days. Not really sure yet what good cause means, but you do have to have this process in place. If you decide to deny the request, you have to explain what the appeal rights are. And so all of this should actually be in the privacy policy before you get into a lot of this, but then you do have to have these steps specifically for this response process. The data itself has to be provided, so long as it's no more than twice in the 12-month period, has to be divided free of charge and in a usable, portable fashion. If somebody has an account with you, you're supposed to give it to them through that account. If somebody doesn't, you need to figure out a way to give them that information in a more traditional manner. You also have to think about what you're going to do if you get an incomplete request. As I said to a client in an email yesterday, if you say, in order for me to give you the information, I need A, B, and C, but instead you get X, Y, and Z, what are you going to do with that? Are you going to kick it back? Or are you going to try to process it? And you just need to know what that process is going to be up front so that you're prepared to explain it and to implement it consistently. You are obviously permitted to verify that the request comes from the actual consumer. Exactly how you choose to do that remains to be seen. There are a number of options that are proposed. Companies are permitted to have a high degree of certainty as to the requester's identity. You are permitted to consider the likelihood, as this indicates, that fraudulent or malicious actors might be trying to get the information. And you are permitted to, therefore, to take reasonable steps. You also are required to provide opting out. Now, the two magic phrases appear on this slide. What we don't know yet is what the button itself is going to look like. The Attorney General is holding hearings up and down the state this week, and one of the topics on which he wants input is what this button should look like. So for right now, all we know is that you can use one or the other. Now, if you don't sell consumer data, you have the option not to do this. What we're seeing is a lot of companies that do not sell data are nonetheless providing a page that reads either do not sell my personal information or do not sell my information or some variation of that. And they're saying, we don't sell your information now. If you'd like to give us following data so that if we do in the future and you want to opt out, you can do that. So this is one of those where there's not a clear mandate in terms of companies have the flexibility to say we're going to implement this in a slightly different manner. But it does certainly apply if you're selling the data or if you're sharing the data. Here's some questions to think about. For example, I said earlier you can't discriminate if your consumers, if your customers decide that they want to take advantage of any of these provisions. So if somebody wants to opt out and you've got millions of records and this handful of people want to opt out, you can't discriminate them against them. You can't deny services, you can't deny goods, you can't charge them different prices or rates or provide different levels of service quality unless those differences are reasonably related to the value to the business of the consumer data. Not really clear what that means at this point. But there is an acknowledgement in the law that loyalty and financial incentive programs are still permitted, but you do need, again, to make disclosure in the privacy policy as to what you're doing. California consumers also have the right to be forgotten unless the data is necessary. This is kind of analogizes to the legitimate use provision that's in the GDPR, but there is no right to correct as there is in the GDPR, so that is at least one benefit. When it comes to the data of minors, whereas the general use of data for everybody else is on an opt-out basis, under the GDPR for those basically to age 16, it's an opt-in process. So you need to think about that as well in terms of how you're collecting the data and who your target audience. I want to talk briefly about enforcement. and then we're going to open this up to questions, and I think we've got some already, and if not, we'll come up with some. So first of all, enforcement is in the hands of the Attorney General with fines capped at $7,500. Class action and private right of action are specifically barred. However, the way this is written, I said earlier, if the data is not encrypted or not redacted, there is a significance to it, and that is where this comes in here. If you keep the data in a non-encrypted or non-redacted manner, and you are subject to a breach, the consumer is permitted to file a civil action. They are permitted to recover between $100 and $750 per consumer per incident, or actual damages, whichever is greater. There is, however, the right to seek an injunction or declaratory relief or any other relief that the court deems proper. The point is, though, that if you have the data redacted and or encrypted, that you can avoid this kind of consequence. One of the more interesting things that came out of one of the bills that was approved at the end of the legislative session is the last provision on this slide. So nothing really changed in terms of the data has to be encrypted, the data has to be redacted to avoid any potential liability. What did get added was sort of, maintain the reasonable security procedures and practices appropriate to the nature of the information. But the last provision says when a court is looking at this, they're to consider any one or more of the relevant circumstances, including but not limited to the nature and seriousness of the misconduct, the number of violations, the persistence of the misconduct, and the defendant's assets, liabilities, and net worth. So obviously those that are larger companies are going to want to be much more persistent in their procedures, policies, more precise, and so on. One of the things that was the focus of a lot of effort towards the end of the legislative session was whether or not this notice of claims provision would be flipped. The way it currently reads and the way it ended up reading is that prior to initiating any civil action, the consumer had to provide the business with 30 days written notice, identifying the notice by reference to specific provisions of the CCPA. That did not change. What also did not change is if the business is able to cure and does so within the 30-day period and provides express written notice about the cure and assurances that no further violations will occur, neither the individual nor class action lawsuit may be. However, that does not apply if somebody is out of pocket cost. So for example, they had to pay for the monitoring service. They had credit cards compromised where they ended up being charged. Those kinds of things are still going to be able to be charged, to be assessed in some kind of a civil lawsuit. However, all that having been said, if the violations continue, then the consumer is able to proceed with a lawsuit. However, that lawsuit has to rely on violations of the CCPA and not other grounds. All right, this is not directly related to the CCPA, but these are good practices for any kind of data security, and so we thought they were worth mentioning as we start closing slides. Written policies and procedures, they should be precise, they should be current. One of the interesting wrinkles in the CCPA is that you have to update your privacy policy every year. So besides just changing the effective date at the top and maybe at the bottom of your policy, you may also want to be looking at what are you changing, how are you changing it, making sure that what you have is currently, or is current rather. You want to also obviously have an incident response plan. Your actions should be both appropriate and reasonable. And then, of course, you have to look at the question of your service providers. How are you dealing with vendor management? How are you dealing with indemnity provisions? There are provisions in the CCPA that if you are taking data from a third party, you can rely on that third party's compliance. But then, of course, that's a point you want to make clear in your own privacy policy. And if you're giving data to a third party, don't be surprised if they ask you for indemnity, that you are in fact compliant with the CCPA requirements. All right, we have a beginning. Feel free, please, to turn in any questions that you have. If we don't get through all of them, we will make sure that we get everybody answers. So the first question reads, if personal information includes a consumer's IP address, is it correct that almost any business with 5,000 quote-unquote visits could be subject to the CCPA? The answer is yes. IP addresses are the kind of data that is considered personal. So if you've hit the 50,000 consumer household or device level, then you need to look at what you're collecting very carefully and make sure that you've identified whether it falls on any one of the slides that I've given you. The question is, if you're using the IP address, how are you using it? What are you doing with it? What else are you marrying with it? Are you getting data from other sources that you are then putting together with the data you have, so that now you've got not just your own data, but the other party's data, and therefore you're actually able to identify the individual rather than, for example, quote unquote, just the household. We had set this for 30 minutes. We are pretty much at that point, so I want to give one more option for anybody to turn in a question, which I'm not seeing come through, so I'm going to vamp here for just a minute. Just to be clear, the regulations themselves, as I said, will take effect on July 1. So there is some doubt in the parts of some folks' mind about how far they have to go by January 1. I think it's reasonable to look at the GDPR approach, which for a period of time sort of allowed folks to get used to the idea of what they were going to need to do. We don't actually have that indicated to us from the Attorney General, but since we've got this basically 6-month window where the law is there but not a lot of the meat on the bones, that would seem to be a reasonable approach. One of the other questions folks are going to have to ask is, or decide upon, is when it comes to the employee information that's where it's been put off for a year. As I said earlier, you want to think about whether you want to implement some or all of that now, at least by putting it in the privacy policy that's available online, or whether you want to wait. So one of the questions we have is, would this law apply if consumers send in their information on product warranty claim? I'm going to assume that that product warranty claim is going to include things like name, address, and so on. And so presuming that they are California consumers or California residents, the answer is yes. The only broad exception that applies is if the information is completely out of the state. So in other words, you can't take a California consumer, move them to Nevada and collect their information and say you're not subject to the CCPA. So if it's got anything to do with California residents, the answer is yes. If a single consumer accesses a website via multiple devices, do you count the number of devices separately? Yes. That's why I was saying we've got 9 devices in the house, and so that's going to make counting the numbers quite a challenge. Once a person opts out, does it expire at any time? And we have to ask again if they want to opt out. There is no indication that opting out expires. You may, as a matter of course, want to periodically ask the consumer to confirm that they want to opt out. You may want to do that particularly if you're adding new features that you think might be of interest to consumers broadly, but there is no expiration date. And so with that, I think we're going to call the time. Thank you all for participating today. Feel free to send any questions that you think about later. As I said, we will be sending you the slides, and you can feel free to respond to that email with any questions that you think about later. Thanks again for your attendance, and we look forward to hooking up again on another one of these webinars.